What's up, guys? Brian Fell Law Group PLLC with your Florida Law Weekly case update. I hope everybody's having a marvelous Monday. I got 3 cases for you. The first one is of particular importance to me because it's against the University of Florida. As an FSU graduate, a Knoll, I love it when University of Florida loses, and they lost in this case. They lost at the Florida Supreme Court level. And so this has to do with whether somebody can sue University of Florida for tuition and fees that were incurred during COVID for services, for on-campus in-person services that were never provided. So a student sued the University of Florida saying that they paid these application fees and various other fees for on-campus services that they never got because in spring and summer of 2020 they weren't able to attend the campus because of COVID. And so at the DCA level, University of Florida actually won because of sovereign immunity. Sovereign immunity, of course, means that you can't sue a state agency unless the state allows you to do so. And so in order to sue the state under a breach of contract case, the case law basically says you have to have a specific contract that allows you to sue the state. And so here the University of Florida is saying that this student didn't have any particular specific contract that allowed him to sue the state. And so that got reversed. The Florida Supreme Court said, well, they may not have a specific, actual contract, but they had various documents and they had contractual relationship with the University of Florida. And the University of Florida has an implied covenant of good faith and fair dealing, just like everybody typically has in any sort of contract. And so just because they didn't have a specific contract, they were still able to sue the University of Florida. So this is a class action. So if anybody's part of this class where you're able to get your tuition and fees back, or at least some of it, for the time during COVID that you weren't able to go on campus, that's great for them. I'm sure this is going to apply to all the universities, public universities throughout Florida. So, but good to see the Gators lose one. Next case is a family law case. This is out of 6 DCA. And so this case is good for family law nerds like myself. It has to do with the case of Zold versus Zold, which is when spouses are getting divorced or there's some sort of child support issue. A lot of times spouses that are self-employed or they have their own business, they like to maintain income in the business and not distribute it to themselves. And then they say, well, I didn't distribute it to myself. The business didn't pay me this income, so I don't actually have this income available to pay child support or alimony, to pay any support obligations. So, of course, self-employed people do this all the time. And so the legal test says, well, wait a minute, what was the business purpose for you retaining this income in the business? Now, the issue in this case was on the person's tax returns, it showed him making a lot of money because with a pass-through entity like an LLC or an S corporation, the business is not taxed itself. Instead, the tax liability flows through to the owners. So the owners show a big tax liability on their income taxes. And the spouse was saying, well, just because I show a lot of money on my income taxes doesn't mean that money is available to me to pay child support. And so the Zold test says, okay, well, let's look at number 1, the extent to which a shareholder spouse has access to or control over the pass-through income retained by the corporation. And here, although this gentleman was the majority shareholder and the CEO, they said there really wasn't any evidence that he had specific control over the income that passed through that was retained in the business. And then the second prong is the limitations set forth in Section 607. This has to do with basically corporations are not allowed to distribute a certain amount of income if to do so would make them insolvent and unable to pay their creditors, but that doesn't apply. But the real test is the third prong, and that's the purpose for which the pass-through income has been retained by the corporation. And so again, here there really wasn't any information available at the trial, at the trial level showing that the business retained this income for an improper purpose. Instead, it was used supposedly to pay the owner's tax liabilities, to pay payroll, and for other business purposes. And so if you're going to try to show that a business is retaining the income for an improper purpose, you're going to need to show some sort of evidence of that. At least something to show that it's not being retained solely for a corporate purpose, and that wasn't the case here. Now, the only thing that got reversed was the way this company operated was it would first pay the owners an amount sufficient to cover their own tax liability. And apparently there's a split in the DCAs. And so there was a certified conflict in this case to the Florida Supreme Court, because two of the DCAs actually say that money that's distributed to a spouse by his company to pay his own taxes that's not available to him to pay child support. But the court here, this is a new 6 DCA, they said, yes, we're going to say it really was paid to the spouse. If the spouse had a tax liability, the company takes money out of the company, distributes really to himself to pay his own tax liability. So that was money that was available to him and that was actually paid to him. So that money was able to be counted. But if you're in, I believe it's the second and the second and the fifth, I believe, DCAs, it's the opposite. And so money that's used by a company to pay the owner's own tax liability is considered not available to him. So we'll see how it goes, but be careful which DCA you're in. Last case is Zargari versus Zargari. This is out of the first DCA. I thought this was interesting. There was a lot of family court cases in this last issue of the Florida Law Weekly, but just to narrow it down, this last case was interesting because number one, it held that for an attorney's fees argument, let's say you're not awarded attorney's fees, you have to file a motion for rehearing, reconsideration, in order to be able to prevail at the appellate court level, at least in the first DCA. They said that argument was waived. The wife wanted more attorney's fees. She was awarded $20,000 in fees, temporary fees. She wanted more fees because this was like a $14.2 million estate. She was also complaining that she didn't get enough equitable distribution. And so, but the court affirmed that on appeal because there's a lot of discretion when you're appealing equitable distribution. You really have to point out to the appellate court why the trial court erred, why it abused its discretion. You can't just, like in this case, the lawyer for the former wife basically just raised a bunch of issues in his brief, but didn't really go through and explain exactly how the trial court abused its discretion and arrived at an inequitable result in the equitable distribution. And so, but for as far as attorney's fees, you really have to file a motion for rehearing, reconsideration in order to present that argument on appeal. The former wife did not file a rehearing on that issue, and so she was barred by that. And the other thing that it was interesting is for the court to award life insurance to secure an alimony award, you really have to have the court make specific evidentiary findings as to the availability and cost of the insurance, the obligor's ability to pay the insurance, and you got to show special circumstances that warrant the security, the life insurance. And so there wasn't any evidence of that. So if you're going to ask for security for life insurance, make sure you show those things. Make sure there's evidence of that in the record, and make sure that there's findings of that in your judgment. Otherwise, it's going to get reversed on appeal. All right, guys. Hope you enjoyed that. Hope everybody has a great week. We'll see you next time.